Hello, good morning everybody. Laura Murphy here for my contracts, and today I'm joined by my colleague Jenny Huzzy as well. So today's webinar is on employee dismissal, so hopefully you're all comfortable and can hear us okay and you have a cup of tea ready to go. So just to give you a brief kind of overview of what we're going to do today, bear with me now. Perfect. So today we're looking at employee dismissal, the pitfalls to avoid, the cost of getting it wrong, and more importantly, how to do it right, I suppose. We look at some cases as we go where Irish employers fell foul to the legislation and cases where employers actually successfully dismissed an employee. If you don't mind, as always, we'll take the questions at the end. I suppose employee dismissal is just one of those troublesome issues that is a constant issue for small employers. And I suppose testament to that is the fact that 40% of all cases heard, well, going back to 2014, but I think the statistic still stands really when you're looking at the WRC, but 40% of all cases are in relation to unfair dismissal cases, and that is by far the majority. So the aim of today is that you leave here with a basic understanding of how of the procedures and the rights of employees and employers when it comes to terminating employment, with a few key tools to protect you and your business. So I'll pass you over to Jenny. She's a few bits to go through with you.
Okay, so take a look at these figures. So we have €3,362,842.15. And that averages out at 15,862.46. So what are these exorbitant figures, I hear you ask? So the figure of almost £3.5 million is the total amount the Employment Appeals Tribunal awarded in compensation for unfair dismissals in 2015. The average individual compensation awarded by the tribunal was $15,862. Now, I think you will agree that these are hugely significant figures, and I'd question as to how many small businesses could actually swallow a fine of that kind of money. Now, of course, compensation isn't the only sanction issued by the tribunals. They can also offer reinstatement, where the employees return to the old position with no break in service, or there's re-engagement, where returning to an old or similar position, but including a break in the service. However, in 2015, there actually was only 3 reinstatements applied and 4 re-engagements. So compensation does seem to be the normal solution and the most common one. And the tribunals do have the power to award up to 2 years' pay in compensation. So the message today really is don't become part of that statistic, and put everything in place correctly. Don't put yourself at risk of these fines. It is very possible to dismiss an employee and avoid these large fines, and I'll talk you through how to do that in just a moment. But first of all, we'll just take a look at some of the background into the legal framework around dismissals and unfair dismissals. Okay, so there's 3 types of unlawful dismissals that are recognised in Irish law. You've got the unfair dismissals, which is governed by the Unfair Dismissals Act. And as Laura said, with those unfair dismissals taking up the highest percentage of the WRC cases, that's what we're going to focus on today. You have wrongful dismissals, and this is where they arise at common law. An employee can bring a claim for wrongful dismissal where the dismissal breaches the employee's terms and conditions of their employment. For instance, where an employer has not given valid or proper notice to the individual. And those dismissal claims can be brought to the circuit or the High Court. And normal eligibility criteria doesn't apply in wrongful dismissal cases. You also have then constructive dismissal. A claim for constructive dismissal arises where the employee terminates their own contract, but does so because he or she believes the employer's conduct leaves them with no alternatives. The employer's conduct must constitute a significant breach, and that generally goes to the root of the employment contract. So we just wanted to take a look at that information so that you're aware of the different types of dismissal. But as I said, today we're going to focus on unfair dismissals. Okay, so moving on. When looking at who can claim for an unfair dismissals case, there's 3 main criteria in relation to who it can apply to. So the Unfair Dismissals Act applies to employees who have 12 months service. They must also be over the age of 16. And finally, they will have not reached the normal retirement age for their employment. So if there is no retirement age provided for in the contract, then the employee can continue working, and any dismissal may give rise to a claim for unfair dismissal. So in this regard, we would advise ensuring that you have a retirement age in the employment contract if your intention is that people leave after a certain age.
Yeah, sorry, Jenny, just to pick up on that point, because it's probably the whole area of retirement is just, it's seen some changes of late, I suppose, with the Equality Act 2015. So to just give you a very brief synopsis, prior to the 1st of January 2015, employers were able to fix a retirement age and specify that in their contract. Now, however, employers can only fix a retirement age where they can objectively justify the retirement age. So just as a slight aside from what we're talking about today, if you have a retirement age set in your contract, do review it and ensure you have a complementary policy in place that clearly explains why you have that policy in place.
And just on note of that, I'll briefly just show you in the software itself. In the company handbook, you have got the option of actually adding in the retirement policy, and again, it should only be implemented if, as Laura said, you have a retirement age applied in the contract and if it is justifiable. Okay, obviously this is just a sample policy, and it would need to be adjusted or amended to suit, you know, each individual employer's own requirements.
Absolutely.
Okay, so moving forward then, so we've looked at who it applies to, so let's look at a quick look at who it doesn't apply to. So persons working for a close relative in a private house or a farm, provided that they both live in that same house or farm. Members of the defence forces, so the Gardaí and civil servants, officers of health boards, though I don't think anybody today really falls into that category. Only employees are covered under the Act. So contractors or subcontractors, for example, would not be covered. So we look there at the contract of versus the contract for services. And individuals on a fixed term or specific purpose contracts where the written contract excludes that legislation. It is extremely important to have contracts in place, and that really comes into play when you're looking at terminating or not renewing a fixed term contract. So employers need to be aware that non-renewal of a fixed term contract can lead to a claim for unfair dismissal unless the employer can show that the contract was a genuine fixed or specific purpose contract and there was an objective justification for using such a contract in the first place. The employer should always put in a fixed term or specific purpose, a specified purpose contract the right to terminate early. Otherwise, the employer is obligated to continue with the contract for that employee for that fixed term, and early termination could lead to a successful claim to be paid for the balance of the contract. Okay. So the claim. So the process of actually having a claim brought against you by an employee, the main reason why we want to touch on this is because it is such a new process. Obviously, as you should be aware, from the 1st of October 2015, the Workplace Relations Commission was set up, and there's a whole new structure put in place as to how claims can be raised and how they're dealt with. It has been a very much positive change. The new structure has simplified, streamlined, and has quickened the whole process. And the WRC's first year report has actually shown that there's been significant reductions in the waiting times for hearings, and also a reduction in the backlog of cases that previously had been held up in the Labour Court. So as before, an employee will have 6 months from the date of dismissal to submit their claim, and that can be extended to 12 months in exceptional circumstances. That hasn't changed. What has changed, however, is employees who wish to bring an unfair dismissals claim against a former employee, they must submit a complaint form to the Workplace Relations Commission. Initially, the case can be referred to a mediation officer, and this would be where the Commission feels the complaint can be resolved through mediation, but both parties must consent to that. If that's unresolved, then the complaint would be referred to an adjudication officer for a hearing. This would be the equivalent stage of the employment tribunal, and the key difference there is that it's heard by just one commissioner rather than 3 representatives, and those cases are also heard in private. So any appeals arising from an adjudication officer's decision, they can be appealed in the labour court.
Just to come in there, Jenny, and just to say, where an unfair dismissal claim is brought against you as an employer, it is presumed that the dismissal has been unfair. So that leaves the employer with the burden of proof to show that actually, no, the dismissal was fair. So you might say that the odds there are all stacked up in favour of the employee, but that's not to say it's not possible to actually prove otherwise and prove that the dismissal was fair, and we'll talk you through how to do that now. So how do you dismiss an employee? So all of what Jenny has been talking about leads us up to the question, how do you dismiss the employee correctly to protect yourself and your company, and to avoid ending up in the WRC or worse. So to show you this, we thought about common questions and cases that we hear from our customers, and we thought we'd talk through dismissals using some examples to hopefully make it a little bit more realistic, I suppose, for you. So the first, in line with that then, the first type of dismissal that I want to talk to you about is dismissal during probation. Now, Jenny has already stated that unfair dismissals will not apply to employees with less than 1 year's service. However, as employers, you should bear in mind that this does not give you carte blanche in how you dismiss somebody who has been with you less than 1 year. So I suppose to illustrate the point, I want to share with you a case from a company, we'll call them Water Coolers Limited, and they were in the water cooling business. So they had a new employee who they had given a contract to quite correctly, and in that contract it stated that during the probationary period the disciplinary policy did not apply. So this is common practice, this is perfect, this is so far so good, and this is what we would recommend to include a similar policy in your contracts for your new staff. After a number of weeks in water coolers, they became aware of a number of performance issues with that employee. So they called the individual into a meeting where they dismissed the employee at the meeting. So at this point, I'm actually going to turn the situation over to you guys and ask you the question whether or not you feel this dismissal was fair. So we're just going to pop up a question on your screen, and you'll have an option to say yes or no, I believe. My colleague is just sticking it up on the screen. Results are coming in there. How are we looking, Jenny?
Okay, so they seem to be quite interesting. They're what are we, 35 yes, 64 no.
Yeah.
Okay, so it seems to be majority
saying
no.
Yeah, so you've got it in one, guys. This case was ruled to be unfair. So even though the employee had less than 1 year's service, they brought a case under the Industrial Relations Act, and they were awarded €6,500 for being dismissed in that way. So this is a really useful case when considering dismissal during the probation period. We can see that although this individual had been with the company less than a year and they had not accrued unfair dismissal rights, they were able to bring a claim against the company under the Industrial Relations Act. So when dealing with dismissals during the employee's probation, employers need to ensure that they exercise care and fair procedures, and that natural justice will apply. So what does all of that mean? What should the company have done? So I have a few tips now just to go through to you to how to manage your new starter. Probably, to be honest, I could spend the whole webinar talking about induction and new starters, but I just want to give you some key points here. So firstly will be to issue a contract of employment. So legally this really should be given to all new employees within 2 months of starting employment with you. However, I would advise just really giving this on the first day, if not before. Your contract should include a probationary policy. This is really, really important if you want to manage your new starter. And the purpose of the probation policy is to give you, the employer, an opportunity to assess your new employee's performance and to help ascertain really whether or not they're going to be suitable for your company. So if you decide that no, they're not right, dismissing them will be a lot easier if you do it when they have less than 12 months. but it will be key for your probation policy to clarify that the company's disciplinary procedure does not apply during the probation. And we did see that the water cooler company did that. It was just the process that they followed then after that didn't match up with the fair proceedings. Second step that I would say in relation to your new starter is to issue them with a staff handbook. Give your staff an opportunity to read through the staff handbook. Your company policies, your procedures, they'll outline to your new employee what is expected of them and what they can expect in return from the organisation. So I suppose it's a great way to get the new employee singing off the same hymn sheet, if you like, and just helps bring them up to speed, making them as effective as possible, as quickly as possible. So this will be part of your induction process. So the third and final point here really is managing the probation period, and this is where our water cooler company failed. They didn't manage the probation period. So you need to hold regular meetings throughout the probation period, giving the employee feedback on how they are doing. So I suppose if you have a 6-month probation period, I think it would be kind of standard or normal, or definitely I would suggest having a meeting maybe after 2 months, 4 months, and then a formal one at the end. So any such meetings, informal as they might appear, really should be documented, and you should keep notes on them. And then at the end of the probation period, there should be, again, as I said, the formal review meeting, and then at that stage you can decide to extend the employee's probation if you are unsure. However, never extend it really, I would say, beyond the 11 months, because you have to take into account, if you decide then at 11 months to go ahead and dismiss them, you have to take into account any notice or any accrued holidays that might just push them over the 12 months. So just be wary of that if you are extending. Really, to be honest, you know, by 11 months you really should know if this employee is worth it or not. So like 9, 10 months is really more recommended, but absolute minimum, or maximum should I say, would be not to extend it beyond 11 months. And it should never be a surprise to the employee at the end of their probation period that they are dismissed because of poor performance. So what you really want to be doing is holding your regular review meetings, letting them know that A, B, and C are areas that they need to work on, and this is how they're going to work on them, and that you're going to review it in 2 months' time and see how they're going then. So they should always be given the opportunity to improve, never just walk in and dismiss them there and then. And just use that probation period, use your first year to manage your new starter, and don't get to 12 months with any doubts. And we get those calls from time to time where we have customers who are on the phone and they're saying that they're here a year next week, what do I do? Don't get to that situation. Manage your 6-month period, and it'll be a lot easier to dismiss that employee. Okay. So we'll move on then to your employee who now has 12 months plus service. And it's not always as simple as managing a new employee. And an employee who was perfectly working out really well for a number of years, you know, things can go askew or awry. And in the employee relationship, that can happen at any stage, regardless of how long your employee has been with you. So 2 key points here when looking to dismiss an employee with longer service. Those 2 key points are, firstly, that you must have substantial grounds for dismissing the employee, and secondly, that in doing so, you applied fair procedures to the process. So these 2 points are really, really critical, and they're what any WRC adjudicator will look for. If you get these 2 points ticked off, you will have, or more than likely have, a fair dismissal.
That's an interesting point, actually, Laura. There was a case there quite recently. We have it up on our blog page. We've called it the jam tarts case. And it's basically indicating there that once you have those substantial grounds and you've applied the fair procedures, you absolutely can dismiss somebody fairly. The company in this case followed their own procedures to the T, and the employee was fairly dismissed for taking 2 jam tarts. Mm-hmm. So
it's a funny case, absolutely. Yeah. Who would have thought that you could dismiss somebody for taking 2 jam tarts? But it's a perfect case to show that if you take your right steps, you can actually do it. The full details are on the blog if you wanted to have a little bit more of a read about it. So if you are considering dismissing an employee, just taking the right steps and implementing a fair procedure just will be key. So firstly then, let's look at the grounds. We're going to look at that first box that we wanted to tick, the grounds for dismissal. Legislation specifically states what are considered these fair grounds for dismissal. So to go through them, we have Capability, is the person able to do the job? Competence, and qualifications. So qualifications, if you hire a swimming instructor, are they fully qualified to be that swimming instructor? So you've got conduct. It is fair to dismiss an employee where there has been a serious behavioural issue, or where there are a series of minor continuing issues that would amount to gross misconduct. So, for example, continued poor timekeeping where there's no improvement, or on the more serious gross misconduct scale of things, serious damage to company property. So also redundancy, that can be a fair reason for dismissal. Things to bear in mind there, of course, is that the basis for selection is fair, and that, again, the redundancy process is fair. So again, that's probably another webinar topic in itself, but just to mention today, I suppose, that redundancy is a fair grounds for dismissal. Another fair reason for dismissal would be the fact that continuation of employment would contravene another statutory requirement. So I suppose a driver who has been banned from driving, and you can't continue to employ them if they're no longer allowed to drive. And finally, any other substantial grounds. So this is probably it's a really catch-all phrase, but we look to case law to kind of see what do we mean by other substantial grounds. So generally, we're looking here at a breakdown of trust and confidence. So I think all in all, from these points, I take from it that there are quite a few reasons that you actually can dismiss somebody, and really they are quite broad. So in truth, there are many possible reasons that you could justifiably dismiss somebody, and hence and therefore achieving that first tick from our previous is quite doable. So just before we move on to the second step, the fair procedure, I just want to touch briefly on what are the automatically unfair reasons for dismissal. I've listed them here on the slide. I'm not going to go through them all in detail. You can see them there. But just to say that dismissal arising from any of these grounds here is automatically unfair. And talking about the unfair dismissal rights accruing after 12 months, employees who are dismissed for the following reasons, they do not have to have the 52 weeks or the 12 months continuous service. That they're automatically unfair regardless of length of service. So if you do dismiss an employee based on any of the above, you are going to find yourself in front of the WRC, and you are going to find it incredibly difficult, if not near impossible, to defend that case. Did you have a case recently on this?
Yeah, there was actually a case quite recently where an employee was awarded nearly €13,000 by a tribunal because it deemed the employer let the employee go because of his membership of the trade union. There was no fair procedures, nothing was put in place, but he automatically fell into that automatically unfair dismissal because his membership of the trade union was the reason why the employer actually let him go, and that is deemed to become automatically unfair straight away. So off he toddled with 13.
Yes, it's a significant amount for any small employer. Okay, we'll move on to our fair procedure. It is paramount that a fair procedure must be followed if we're going to tick that second point that we talked about earlier. Often employers believe that they have a fair reason to dismiss, but they end up on the losing end of the WRC case because of the incorrect procedure. Statistics show, and there's research to show, that 80% of unfair dismissal cases are lost, not because the employer did not have a good reason for the dismissal, but because they failed to follow the fair procedure. So that's a bit of a shocking statistic too. So in order for the employer to dismiss an employee, even in instance of gross misconduct, you are expected to have a clear and documented procedure in place and to have followed it. So this procedure is usually included as part of your disciplinary procedure, which is generally set out in your employee handbook for the most part. There is, talking about the legal obligation to provide a contract, there's also a legal obligation on employers to provide their disciplinary procedure or their dismissal process no later than 28 days after the employee has started with you. So I really can't stress enough how important it is to have your written disciplinary procedure in place and for all your employees to be familiar with that procedure. If you don't have the disciplinary procedure in place, you dismiss somebody, you will find it difficult to defend your case.
Okay, so just actually we'll just jump into the software there, Laura, if that's okay, just to show you on Bright Contracts itself, within the handbook, the actual disciplinary policy that we have. It is a fully inclusive disciplinary procedure, and this generally would act as your framework to all dismissals. If you want to dismiss someone, this is your first point of call, and your reference guide. So it is very important that it is very thorough and has everything in it, which obviously the policy we have for disciplinary procedures in the Bright Contracts handbook does.
Yes, it's really useful having these policies in place because, again, not only does it act as your framework, but it ensures that you're managing your employee issues consistently as well. And that's going to be key as well, that every WRC adjudicator will look for as well. Okay, so to push on, sorry, I'm going backwards. Apologies. We'll move on to the informal procedure. A disciplinary procedure will normally include an informal procedure. So first instances of minor misconduct, so if it's the lateness, if it's unsuitable dress code, appearance, or poor performance, often they result in informal action being taken first. So this can simply involve your manager sitting down with an employee, highlighting that there is an issue, asking the employee if there is a particular reason for the issue, and then laying out what exactly is expected from them or what improvements need to be made. An informal procedure, it can be a very useful tool for nipping something in the bud before it escalates. And then if the approach is not successful, you then continue on the line of the formal procedure. So the informal procedure to me is really a positive tool. For employers, it's a great way to show how reasonable you are and that you are supportive and that you want to help your employees where you can. And these are two key points, again, that the WRC adjudicator will look to see. They want to see that as an employer, you're reasonable and you're supportive of your employees. Now, I suppose just to point out a couple of pitfalls that we see from time to time in relation to the informal procedure. The first would be failure to take notes at the employee meeting. So although it is an informal meeting, it really must be documented if you want to be able to confidently progress and push yourself along to the next stage when required. And then that's the second pitfall I often see, is that failure to actually go ahead and progress to the formal stage. Employers, we find, again, from time to time can often let things linger, and they'll just have informal chats every so often, and then they'll have another informal chat, and they're not really addressing the issue. And I know it can be hard, particularly if you're in a small organisation and everybody's on friendly terms, but in order to deal with those issues appropriately, you need to be able to move to the next step when necessary, I suppose.
That's something that actually comes up a bit on the phone, Laura, in relation to an employer who feels he's got to the stage of wanting to dismiss an employee, and the procedures he's taken is he's sat down with this employee 2 or 3 times over the last 12 months, let's say, and has had the informal discussion, but actually never documented it and never moved it forward. And unfortunately, the case of it, when it gets as far as the WRC, that's just not.
It doesn't really count.
It doesn't count for anything, exactly. Yeah.
Through the process. So that leads us on then to, well, what is the process, I suppose? I've set out a suggestion here of what a fair procedure might look like. Now, unfortunately, the concept of fair procedures, it's not a static one, and what is required and what is considered fair really will depend on the particular circumstances of the case. So there's no one-size-fits-all procedure that can be adopted by employers when implementing a disciplinary procedure. The seriousness of what is at stake, for example, and the seniority of the employee may impact on the extent of the procedure required. However, that said, there are some core basic steps that your formal procedure should generally take. So to go through them briefly, because we'll talk about them in more detail again, but firstly will be to investigate in order to establish whether a disciplinary hearing or whether you need to proceed with the disciplinary process is required. So that's going to be important. If you decide, yes, we're going to go ahead with disciplinary proceedings, you're going to then invite the individual in question to a disciplinary hearing. So this is really important. You're not just going to haul in, jolly, right now, immediately, I'm going to deal with this issue straight away. You have to send a formal invitation, giving them notice, and that again has to be in writing. So you'll then hold the disciplinary hearing, and I suppose the key point for managers here is to stay impartial. you know, that can be difficult, and I've seen it time and time again, particularly in small businesses. If you're the manager, it's your business, you're the owner, and so quite understandably, managers can take issues personally. But really, the key here is to take a step back and try and be impartial. So you'll hold the disciplinary meeting. You then end the disciplinary meeting, and you'll go away and you'll consider the facts. This is done after the meeting. You never make a decision or communicate a decision at that initial hearing meeting. You have to go away, and the WRC have to be able to see that you took time to consider all the facts and to consider any argument that the employee put forward at the hearing. So once you've done that, then you will issue your decision. Again, this will be confirmed in writing, and there will be the opportunity for the employee to appeal. Again, that's a must in your decision. And then depending on the decision or the sanction given, you will move on to either A, dismiss an employee, if that's the stage you're at. Although I will say that dismissal really should be a last resort. So more than likely you'll be given a lesser sanction, and you'll put in a review period in place, and you'll monitor the individual during that period. And again, that's kind of in line with what Jenny's saying as well. It's really important to monitor that review period. There's no need, if you say, well, you've committed such a crime, I say, and we're going to review this over the next 6 months. When that 6 months elapses and there's another incidence of whatever the case may be, you're basically starting back over then, because your 6-month period has ended. But I'll talk a little bit more in detail about these points in a couple of moments. But I want to go on now to our second fictional case this time. So everybody, this is John. John is a bus driver for ABC Transport. ABC Transport provides a local school bus service. John has been employed for 3 years, and on one particular day he arrived into work obviously under the influence of alcohol. The company has a strong no-tolerance policy for alcohol and drugs, particularly because they are transporting children. John was dismissed on the spot. So this is question time again for you guys, and Macaulay's going to put up a question for you. Would you say that this dismissal would be ruled fair or unfair?
Wow, okay, we've got 50-50 on this one. Okay, we're moving more towards the unfair. Nope, come back to 55-45.
In favour of?
60% are saying unfair, 40% are saying fair.
Yeah. Okay.
So it's quite mixed. It's very mixed.
Yeah. And it is. We'll go with it. It's unfair. Now, if we said it's a fictional case, we're going to go case. But it's more than likely that was going to be. Should John brought a case against the employer. Now, although the company could probably have argued that John's behaviour did constitute as gross misconduct, particularly because they have a no-tolerance policy, so they would have had the substantial grounds for dismissals. They would have ticked that first box. But what they didn't do was implement any type of fair procedure. So when we talked earlier about the 80% of cases being lost because of procedure, this is just a prime example. They've got a really strong reason to dismiss, but they didn't do it correctly.
And this again is something that comes in quite a lot over the phone. And you know, the majority of people, as we can see there from the poll, you would assume when the employee hits that gross misconduct and has absolutely, you know, kind of broken the rules in relation to a no tolerance policy, unfortunately you cannot just get rid of that person. There is that fair process, those procedures and steps that need to be taken before you get to that point.
And we'll go through that process now, but don't be put off and go, there's a whole process. For something like this where it's gross misconduct, the process can move quite quickly, but you do need to take steps. So it could be that the whole process is done within a week and a half, but to take that time to do it properly and protect yourself really is worth that time for the week or whatever it is. So what would the steps be? Okay. So what should they have done? So firstly, they should have suspended John. So due to the severity of John's actions, it would in this instance be acceptable to suspend John. Now, I wouldn't say that in all cases, but as we're talking about gross misconduct here, they would have been allowed to dismiss him to allow a disciplinary procedure take place. to point out here, remember that if you do place an employee on suspension pending an investigation, they will receive full pay. So they are innocent until proven guilty, if you like. So the next step will be investigate. In this instance, an investigation may involve speaking with any of the other employees who saw John that morning, and establishing and taking notes from that meeting. So establishing the facts and preparing evidence doesn't necessarily mean a lengthy, arduous investigation process. You know, there might have been 2 other drivers in that morning. You sit down and you have a talk with them. So if you are considering disciplining somebody for performance issues, it may be a case of getting together some previous appraisal notes, notes of meetings, productivity data. If on the other hand the offence or allegation and the alleged offence is something simple and straightforward, the investigation may well too be simple and straightforward. And then obviously if it's something more complex, you might need to do more interviews, you might need to seek client input or undertake audits or computer investigations. But for the case of this one now, I think it will be relatively short and just interviewing people who were there that morning. So we've done the investigation then, and John's manager decides, yes, it looks like gross misconduct did occur and that the disciplinary hearing is necessary. So the manager writes to John and he invites him to the hearing. So the hearing, generally 24 hours notice would be sufficient to give John a notice of the hearing. And in the hearing, and in the letter, should I say, the invite will clearly state the date and time of the hearing, and you must include a brief summary of the matter at hand. And there should also be a note to say that if the allegation is upheld, dismissal is a possible outcome. And this is important. You must warn people of the outcome. Even if you're at the early stages, you must say that if this issue progresses, that dismissal is a possible outcome. And cases have been lost on this point alone. And also then finally, you need to confirm that John had the right to be accompanied by an appropriate person at the disciplinary hearing, and this would usually be a trade union member or a work colleague. So these are quite specific points that you have. These is again legally or through the WRC code of practice. You have to include this in the hearing invitation letter. So moving on then to the hearing. At the hearing, the manager presented the full allegations to John, and John also has access to see a copy of any of the interview notes or any of the notes that were gathered as part of the investigation. And again, that's really important when you're having a disciplinary hearing. So basically at the hearing, the manager will present the case to John and simply ask John to respond to the allegations and to give his side of the story, so to speak. It's advisable that you do have a witness present just to take minutes of the meeting so there's a record of what took place. And again, we've touched on it earlier in the previous slide, the hearing should be impartial and should be fair, and no bias or prejudgment should be shown. So the hearing, it's not about a two-way conversation, it's not a he said, she said. As an employer, I wouldn't advise that you get into arguing with the employee. You're simply putting the facts to the employee and you're saying, what's your side of the story? And that should be it. It shouldn't be an overly lengthy meeting, and then what you want to do, you just want to adjourn the hearing. So you want to adjourn the hearing and you want to go away and consider the facts. So in this case, John's manager considers the facts that John presented, and he makes this decision as to what sanction would be appropriate to issue John with. In this case, because John's actions were classified as misconduct and because no mitigating argument had been put forward by John, the manager made the decision to dismiss John. And this was confirmed in writing again to John, and he was given the opportunity to appeal. Again, this is extremely important. When we talk about the opportunity to appeal, generally we would recommend that you give a week's notice. So the employee has a week in which to submit their appeal, and you must also state who the appeal should be sent to. And again, this should be put in writing by John if you wish to appeal.
Just to point out there, I know for illustrative purposes we've used the case of gross misconduct here resulting in a dismissal, but other possible outcomes of a hearing might be to conduct further investigations. So you might need to, as Laura said, interview more employees, maybe review CCTV footage if it's in place, or issue a letter sanction. So suspension without pay for a period of time. There's other.
Or it might just be dismissal. It could have just been a first written warning or a final written warning,
exactly,
depending on, in this instance, because John was travelling with children, the company took a very there's no tolerance, but depending on the company, the impact on the company might be different. For this instance, we'll assume it was very much gross misconduct, but in some cases it might be a warning that might be issued. So if we think back to our tick boxes and ask ourselves, can we tick off that second point in relation to fair procedures? The answer, if the manager had followed this procedure, absolutely. And I said this again, we talk about procedures, don't get put off that it has to be overly lengthy. I think, you know, a few days, you can certainly go through this. It's just all about being diligent and staying on top of the case, really. Just to go on then to our final case, and this is the type of situation that we come up against quite a lot. So I'll introduce you to Margaret. Margaret is a store assistant and she's been in the shop for 8 years. Lately, the manager has had a number of issues with Margaret. There's nothing really that he can pinpoint. She's been coming in late a few times. She's rude to staff. She's not getting on with her colleagues. There's a couple of instances of incorrect change. So loads of little things that just aren't adding up right. And the difficulty with this situation is that there is not one single incident that you can say, right, you did this wrong. There's just a whole kind of attitude, almost a negative attitude on Margaret's side. So that's the difficulty. And how does a manager deal with this situation, particularly considering, again, that Margaret has been with the company for quite a long time and there never really has been too many issues up until now. So if the employer wants to dismiss an employee here in this situation, you just need to be prepared for a longer process. You're not going to have the quick process that we had with John. So a little bit of patience will be required. Now, again, this is probably a performance issue, and we could probably have another webinar on dealing with managing performance, but I'm going to give a kind of a brief overview of what you would be looking at. So I suppose when we look at all these number of small misdemeanors, they can accumulate into one big problem, and probably maybe the worst kind of problem if it's creating a negative atmosphere in your workplace. So again, going back to our informal procedure, when you have these issues, it's really best not to let them fester, and you need to address these and nip them in the bud before they escalate into something more problematic. However, when you do need to take formal route, what's that route? So going back to our steps earlier that we talked about, so you'll execute step 1 to 4, so the investigation, invite to a hearing, hold a hearing, and consider the facts. So then you're going to do step 5, issue your warning. In issuing a warning, the likely first warning for something like this is probably a verbal warning or a first written warning. I think you'd find it difficult to justify anything beyond a first written warning. However, what you will need to do in addition to this, and what's really important, is that you're going to have to clearly communicate where the gaps in the performance are and where improvements are needed. You'll also need to confirm what support and what assistance the company will provide, and you'll need to give a date when you will review the performance. So this is going back to, again, what we talked about earlier in the informal procedure. The WRC wants to see that you gave opportunity to the employee to improve and that you gave assistance. So you want to be reasonable and a fair employer. And this really will be a bit of a cycle from here on in now, because you're going to review the employee's performance over that period. If there's no improvement in the situation, you may have to repeat the process and then proceed with further sanctions. So that's at the stage that you'll be considering going to a final written warning, and then further, if there's still no improvements, it's dismissal from there. So a little bit of patience is required, but you do need to give the employee opportunity to improve. But again, key to all of this is staying on top of it.
Yeah, but again, kind of coming back to, you know, this kind of instance, patience here is a virtue, although not perhaps the answer that employers are going to want to hear. But going back to the requirements of the fair procedures, this is what needs to be adhered to execute these steps. It's vital that basically the fair procedures are applied, your steps 1 to 4, and then you come up with your decision in step 5. So looking to move on from that, then, just to finish off, we want to look at what sanctions can be issued and for what alleged crime. The sanctions issued should be fair and proportionate. It's the role and the responsibility of the individual conducting the hearing to make that decision. And based on all of the evidence, and to your own company's disciplinary procedures. Most disciplinary procedures will list sample instances of misconduct and gross misconduct and what the possible sanction is for those. So we've just looked here, we've outlined the most common disciplinary sanctions and where misconduct falls into each one. So minor misconduct, generally this will be your verbal warning. And although we call it a verbal warning, as Laura has said previously, it needs to be documented. You need to record all of these, because otherwise, if you're just sitting down and giving a verbal warning on, a number of occasions, and 12 months down the line, you want to dismiss that employee, that's a moot point really, because you haven't documented anything. It might as well have actually not happened. Repeated and minor misconduct or serious misconduct, generally this will be where your first written warning will come into play, and then if that continues, as we said, if it's repeated, then you'll get your final written warning. The gross misconduct or repeated minor or serious misconduct is where you get to the dismissal stage. So you've got action short of dismissal. This can include suspension without pay, a demotion, removal of duties, kind of set the tone as well for other employees. And then the last option really is dismissal. You need to illustrate that you have considered and utilised all the other avenues. And this is in line with the WRC's Code of Practice on the disciplinary proceedings. Good practice requires a number of stages to handling the disciplinaries. And this is what a WRC adjudicator will look for. So only in cases of gross misconduct can dismissal be the first sanction. And I think that's something that we've seen there in the 3 cases that we've looked at.
Absolutely. Just kind of on that as well, when you're considering what the fine or the sanction is going to be, you need to remember that the fine needs to match the crime, if you like. And just for one final case, it was a case of Marks and Spencer's Ireland, and they had an employee there. I suppose the crux of the case was that the employee was doing is he was hiding, he was in the children's department, and he was hiding sale items behind non-sale items on the hangers and in the store, and then later on after a shift or whenever he was able to buy them, he would go pick out the clothes and buy those clothes as a gift for his relatives at the sale price. He was dismissed for that. He brought the case, and he won the case because the judge felt that it was clear that they hadn't really, that the sanction of dismissal was disproportionate to the actions of the employee. He won €13,000 for that case. So just again to illustrate, if you're going to issue a warning, it has to kind of be at the level of the actual crime. Mm-hmm. So that brings our webinar to a close today. I suppose just a few key learning points. Be sure to issue a contract for your new employees. Get that probation policy in place and good and clear. Have your disciplinary procedure. If you just want to protect yourself, the disciplinary procedure is really, really important. And be sure to apply it fairly and consistently as well. That's going to be key as well. So I hope you found that useful. There's a few questions coming in, so just bear with us now until we bring across our question slides so we can get to them. Just give us a couple of seconds here.
So sorry, somebody's come in there with a question. Is it necessary to have regular performance reviews? Absolutely, yeah. Performance reviews are essential to the employee/employer relationship and keeping that communication level open. So that you don't get to, the kind of issues where we spoke of with our long-standing employee, where the employee has become complacent within their role. By having regular performance reviews, you can pose to the employee improvements that they can make. And just that line of communication is vital to that relationship, and hopefully by doing that, it will actually eliminate, that complacency actually coming into the workplace in the first place.
Perfect. There's a question coming in, going back to one of our cases. What happens if John point blank refuses? Sorry. What if John denies point blank that he was under the influence of alcohol? Well, I think this really is where your investigation comes into play, and it just shows the importance of having an investigation, and a good one, so that it's not just John against the manager, and the manager feels, yeah, you were under the influence. So if you can have a number of different interviews in place. You might not be able to show properly, but I think what an adjudicator will look for will be the balance of probability, and that you've taken all the steps to prove on your side that he was.
Yes, exactly, because as Laura said, you know, they're innocent until proven guilty, so it's up to the employer to prove that he is, and the employee to prove that he isn't. So that investigation procedure is absolutely necessary.
Just sorry, one comment in here. When we are taking notes of meetings in the informal procedure, do you make the employee aware that you were documenting the meeting? Absolutely, yes, you should. And generally, I would also advise that if you make notes at a meeting, that the employee should receive a copy of those notes, or definitely know that you're taking the notes, and that they have access to review the notes if they want to see them. So again, it just helps ensure a transparent process.
Okay, so for the unfair dismissals, the fines that can be implemented, or the compensation that can be implemented or awarded to employees, is a maximum of 2 years' pay for an employee. But I'm sure you'll all agree, 2 years' pay for somebody who's no longer employed with you for something simple like not following that fair procedure is a huge amount of money, and you know, most small employers just won't be able to swallow that kind of kickback.
Are you allowed to use CCTV to monitor performance? I'd be cautious about using CCTV to monitor performance, to be honest. The use of CCTV is highly regulated by data protection. So just to be aware that if you are using it, make sure you're following all your data protection regulations. I suppose it will depend on your industry. Be sure you have a really good policy in place, and be sure staff are really fully aware that you're using CCTV. It's an old case now at this stage, but it's Dunn Stores. They have a lot of cases that we could use. We have a lot of Dunn Stores cases, but they had a case that's a few years now, where the employee was caught on CCTV. She was working in the deli counter of Dunn Stores groceries, and she was caught on CCTV helping herself to a few chicken wedges or chicken goujons during the day. She was brought in and she was dismissed. She brought a case against Dunn's, and she put out the case that she didn't know there was CCTV in place. She won the case and was awarded €8,000. So just be careful if you're using CCTV.
You'll also find actually as well as some companies will have like a CCTV policy in place to say that it's on the premises, but if it's not mentioned in it that it can be used to monitor performance, well, then this is where it will kick back.
So you're saying where you have it and why you're using it.
Yeah.
What if an employee doesn't turn up to the hearing? Okay, yeah, this is a good question. It's almost a little bit of biting your tongue, and you have to be reasonable as an employer. So you've sent the invitation, and you said the meeting is on Monday at 4 o'clock. The employee doesn't turn up. The next step that I would recommend for you is to send another invitation letter to the employee, clearly highlighting that you are being really reasonable and you're rescheduling for another time, and make sure that you can prove that they got the letter, and make sure that they can come to you and say, to let you know if this time doesn't suit, or if they need to reschedule for any reason. If they don't come back to you and you know they got the letter, I think give them two options. Reschedule it once. After that, then you're going to write to them and say, so you now haven't appeared for 2 hearings. We're going to hold the hearing without you. So basically, you're just having a meeting where you would document that you have the meeting, but the employee has no opportunity to put forward their case. So then you'll just consider the facts based on your investigation, and you move forward from there.
Okay, now there's a couple of questions coming in about the probation. As Laura said, really, you know, the probationary period initially recommended with the 6 months, but it can go up to 12 months. And as Laura said, really, it shouldn't go past that point. You can extend it after the 6 months, but you know, kind of implementing or increasing it after that, there should be valid reasons for it. Like if you're still unsure after the 12 months.
Just to kind of come in there as well, there's a question here, and I'm not sure if we're taking it up right, but okay, so the employee A has passed probation, but they still haven't passed their 12 months, so they maybe have 9 months service. How do you manage that when you've already passed their probation? The thing to be aware is that just going back to our contract, so what we said in our contract, or what your contract should say, is that during probation, the disciplinary procedure does not apply. So now what will happen is that your disciplinary procedure does apply if they're at a 9-month service. So you should really be going through your disciplinary procedure and the steps and the sanctions, even to create that fair procedure.
Mm-hmm.
The notice period is often longer out of probation. Generally, we keep a notice period to a week in probation. So then, again, it'll all depend on what your contract says. Because your contract might say after probation is a month. So you just need to really be sure about what your contract says.
Mm-hmm. There's a question in there. Does the hearing need to be during their normal working hours and at the normal workplace? You kind of need to be seen to be fair. So if it's a case that the employee, it doesn't suit them to come in during normal working hours, or they're not comfortable coming into the workplace, if they've been put on a suspension or something like that, they mightn't be comfortable, meeting other employees.
It might be appropriate really to have them on site.
Yeah, exactly. So no, I mean, you can have it that you might meet in a different location. It does not necessarily have to be in the work or during work hours. It has to suit both parties, really.
If you give an employee a verbal warning, how can you prove that you did this? Should it not also be in writing? Absolutely. It's called a verbal warning. I think Jenny touched on this. It's called a verbal warning, but it's 100% it's put in writing and to prove that you've gone through that process. There's a few questions coming in. We're trying to get through them all, and there's quite a few. We'll keep on for another couple of minutes. Yeah. We're conscious of the time as well. So if we don't get to your question, as always, we will come back to you later on today.
Exactly. Do you want to look at that last one there? There is quite a few of them coming in, so there's quite lengthy ones as well.
Yeah. What can you do? This is one. What can you do if an employee refuses to engage in an annual review? You've got an issue on your hands there. An annual review, generally, the fact that you have an annual review is generally part of your handbook, and you should state it in there. So, an employee refusing to take part of it, they're refusing to abide by your handbook and your policies and procedures. So you could justifiably enter into a disciplinary procedure for that.
They're in breach of the agreement on the contract by not attending it.
Yeah, and lack of cooperation.
There's one there. Can you dismiss an employee on sick leave for more than 3 months with medical cert? You cannot dismiss an employee who's in receipt of statutory payments.
I think the whole issue of dismissal and sick leave, again, we've had webinars on it in the past, and we would maybe have one again in the future.
Yeah.
For people on long-term sick leave, it's a tricky one. It's certainly not impossible to dismiss somebody when they're on long-term sick leave. You just have to be very careful, and again, it's a process of how you do that.
Mm-hmm.
And it's not certainly, it would go beyond what we've talked about today, because you need to get details from medical practitioners and doctors, etc. So probably it'd be beyond the scope of going into it today, but exactly.
Long-term sick leave generally, yeah. But on somebody on short-term sick leave, generally you wouldn't be just dismissing them for that reason.
No, you'd have to be very, very careful.
Exactly. Okay, well,
I think we've come to the end of.
Anybody we haven't answered the questions for?
Generally, I think we might have missed them as well.
Yeah, there's a couple.
So we'll go through them again after today as well, or after this webinar as well.
And anybody who has registered for the webinar, they do get a recording of it, and we will reply to everybody individually with if we haven't answered your questions, we'll reply to you by email individually. So that's the employee dismissal, and how difficult it is or it isn't. So we're offering a 15% discount off the price of Bright contracts. Now that's a special offer we're offering to you just for the month of April. So it applies to a standard or bureau license for your first year. It's for new customers. So if anybody's interested, certainly you can get in touch and we'll talk you over the phone with it.
Just briefly before we go, I think there's a few questions at the end, and if you had a few minutes, do feel free to fill in if you'd like any more webinars or any other topics that you'd like to hear us speak on, or if you'd like a demo of the software to find out a little bit more detail about all those policies and procedures. So thank you all very much for your time today, and hopefully we'll be in touch and hear from you soon.
Thanks, guys.